Hello friends, in the series on the income tax cases, today we will discuss a very important issue where the notices under section 148A clause B are being issued to the assessees, and after giving the sufficient reply and raising various objections, those objections are not considered in the true sense and notices are issued under section 148. It has been seen that where the notices has been issued on the basis of the statement of some person, then whatever the submissions the assessee gives or whatever the evidences assessee submits, they are not taken care of. They are just kept under the carpet and the notices are issued in a blanket manner. Some assessees which can afford the litigation, which can afford the costly affair of writs, go to the courts, and when these writs are filed, no doubt sometimes the notices and orders are quashed, but they are quashed with a condition of remand back and to reinitiate the proceedings with fresh. So the question arises that if the second inning is allowed to the department, whether it just encourages the officers not to follow the procedures, because they know that if the assessee will not go to the writ, then the assessee will stuck into the litigation, the orders will be passed, and then the assessee will be in the circle of CIT appeal tribunal and High Court and Supreme Court. And if the assessee will go to the writ, then whatever the mistake the assessing officer has done, now he can just remove those mistakes in the proceedings, which can he continue with the remand directions. The same issue has come in the case of Gudwala and Sons and another versus Assistant Commissioner of Income Tax, which has been reported in the ITR 462 at page number 33, and the date of the judgment is 27 September 2023. In the present case, the notice under section 148A clause B issued to the assessee on the allegation that the assessee has taken some accommodation entries from Ankit Jain, the proprietor of Rishabh Trading Company, of an amount of rupees 1.15 crore. The assessee submitted an objection. The assessee said that whatever the statement has been provided to the assessee, that statement does not contain the name of the assessee. The assessee said that there is not sufficient material with the assessing officer that can trigger the reassessment proceedings against the assessee, and in fact the assessee has purchased the goods of rupees 70.10 lakh from Rishabh Trading Company and has made a sale of rupees 45 lakh to them. He has not taken accommodation entries. It was also the contention of the assessee that please provide me the copy of the approval, if there is any, which has been taken for initiating the proceedings against me. And the assessee has also submitted the affidavit of Mr. Ankit Jain, who was the alleged entry operator, that whatever the transaction the assessee has entered with Ankit Jain, that are genuine. The assessee also kept the point before the assessing officer that he can present the Ankit Jain, proprietor of Rishabh Trading Company, to present before the assessing officer that the transactions between the assessee are genuine. But these submissions were not considered and notice under section 148 was issued. So the assessee challenged this notice in the writ court. The court, after hearing the assessee, quashed the notice and remanded the matter back to the assessing officer with the power that he can reinitiate the proceedings. With due respect to the court, if these type of remand back will be allowed, then according to me, only it will encourage the assessing officers that they can go for the various very serious proceedings like a reassessment under section 148, in which the department can move to the 10 years with a very casual manner, without providing the assessee the due opportunity to hear him, and without providing the assessee that the assessee can counter that person on the basis of which the allegations against the assessee are made. And if even the name of the assessee will not be in the statement and the assessee will offer that he can present that person, even then the notices will be issued without giving the assessee an opportunity to present that person before the AO, then it will create a circle for the assessee that he will be stuck into the litigation. The main purpose of going into the writ will be defeated because again the assessing officer will get the opportunity to start the proceedings. Although in this case the notice and the order was quashed, but the assessing officer was given liberty to reinstate the proceedings, so there was practically no relief for the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Gudwala and Sons and Another versus Assistant Commissioner of Income Tax, and this case has been reported in 462 ITR at page number 33, and the matter has been decided by Honorable Delhi High Court, and the date of the judgment is 27th September 2023.